Welcome to the live Q&A on the Advocate Mohammed Abduroaf Facebook page, a platform where we try to answer and engage with you, but specifically answer questions regarding problems that you may face regarding child custody and child maintenance. We had many webinars in the past dealing with those specific topics. We feel it important to advise people and to inform people of their rights, and at the same time to empower you so that you can handle your specific child custody and child maintenance issues as easily and as stress-free as possible. Okay, the questions are coming in. Thank you for that. Please pose some more questions. And I see we have somebody from Somerset West. Welcome. Today's theme would be something which I've been thinking about for some time, and I do not really have a word to, a word to specifically not describe it, but to put it under. Basically, the phrase is toughen up. And the reason why I'm saying so is that having thought about the amount of people I have been advising for the last few months, and how they have been responding to the specific problems regarding child custody and child maintenance, it seems to me that they have to toughen up a bit with respect. And this is a prelude to the conversation. I'm not referring to you. The persons that I'm referring to might not be watching this video. They may be somewhere else, but those are my experiences. And having thought about it, I've come to the conclusion that many cases, especially regarding child custody and child maintenance, are not successful for the client, or they do not receive the required desired outcomes, is solely because they are not toughing up. It's a silly phrase I'm using, and that will be the theme for the next few webinars. You need to toughen up. You need to look past the fact that you have been manipulated by the other party with respect to everyone. I'm not referring to any specific gender here. It could be the male that must toughen up. It could be the female that must toughen up. But you need to toughen up, and you need to take control and ownership over your case. Just some random advice to you. Because if you do not do that, you will have to compare yourself to someone that has toughened up, and who will get a better result? The party that is very anxious about his case, that does not want to proceed in fighting for his or her rights because he or she may believe that he or she may be successful. He or she does not want to proceed with his or her case and fight for his or her rights because they are afraid of the other party. They have been victims of domestic violence, gender-based violence throughout their relationship. Toughen up. It's easy for me to say, I know, but you need to do that. So that's just a buzzword for you to hold at the back of your mind when dealing with your matters. And I'll try to think of a theme, or maybe have a webinar specifically to deal with that. The same with me as a legal practitioner. I'm luckily for me, I have many years of experience going for 2 decades on child custody and family law and other legal matters. But if my attitude was, when I represent a client and I know there's a more senior advocate or an attorney, or there may be a senior judge who, in front of whom I'm appearing, who is giving me a hard time, I have 2 options. I can either fold. I can tell my client, I'm not put out for this case. I can walk away, let someone else do the case. Or I can toughen up as an advocate, take the punches, give the punches, and give the best I can for my specific client. And that is what you must do. So today's theme, and for the next few webinars, will be toughen up and fight for your rights. We have someone from Cape Town as well. Welcome. Thank you for that. Let's deal with the first question. I was given an order by the court for maintenance father didn't appear, an attorney agreed on his behalf. He now refuses to accept and sign the order. What do I do? Now, it's a difficult thing because an order is an order, full stop. And the moment a party, has knowledge of the order, he or she is obliged to adhere to it. The difficult thing what I mean is, it's difficult because the other party is now refusing to accept responsibility in terms of this order, although his or her attorney has agreed to that order on behalf of the client. Then you have to follow the maintenance laws. The maintenance laws specifically stipulate that if a party is not adhering to a maintenance order, it is a criminal offense, and you can have the person, prosecuted for that. And you can go to prison for up to 3 years. Therefore, my advice to the specific commenter is go to the maintenance court, lay a complaint. If the person is working for a boss, you can apply for a garnish order. If the person has certain assets, depending upon the amount, you can have those specific assets attached. So, for example, if the person owes you 100,000 Rand and does not want to pay, it makes more sense to go to the maintenance court and ask for an order to attach his or her car or house, whatever the case may be. I hope that answers that. If you want to add to the comment, feel free to do so. I see the next comment says the following: agree. You have to drive this whole process and be in charge. And I think that goes with the whole issue concerning toughen up. If you do not take ownership of your case, the same way if you're studying for an exam, if you're studying for a degree, a qualification, a diploma, it is up to you to toughen up. You do not understand the work. The work is hard. The lecturer is giving you a hard time. You cannot find the specific relevant material online or in going to the university or to the college, wherever the case may be. You need to toughen up, and start fighting. The same way if you want to lose weight. At the first sign of defeat, what do? You go to the restaurant, you buy food. No, toughen up and lose those pounds. The comment of early on added something else. He says the following: easy to say when you are dealing with someone who refuses to abide to the law and the maintenance officers let them get away with their behavior. Been dealing with this issue for 2 years, and now that I thought the matter was over, the father pulls a tactic and now refuses to sign documents. How much tougher do I get? I cannot take it any further. It's very unfortunate with the maintenance courts and the maintenance systems, how can I say, disappoints you. And it shouldn't be the case. I do not know how to respond to that specific question. It's clearly you had a difficult situation where the situation failed you, but I think there are more resources available. It doesn't end there. If he doesn't want to sign, the law doesn't say you must sign. So if an order gets served upon you, you must not, the law doesn't say that the person must sign acceptance therefore. There is no law that says that. The same way, if someone issues a summons against you and you refuse to sign the summons, all that the sheriff will have to do is say, I attempted to serve it upon him, he did not want to receive a service, and I placed it on his door. I put it somewhere so that he can see it. That is it. So the same applies to the maintenance order. You do not have to sign for it. The sheriff will make sure that he gets it. Tell him, sir, you do not want to sign for it, that's fine, but here it is, put it down and walk away. The commenter goes further. And I'm very happy to receive these comments, and feel free to add as much as possible. His attorney is now playing the game and saying that they are waiting on direction from their client. Those are most probably usual attorney tactics, and the attorney knows how to play the game. I would say go to the maintenance court. That makes more sense to me. The maintenance court will have to deal with this matter. Was the maintenance court being conned? Has the attorney really had the necessary authority to sign that agreement? Lay a complaint against this attorney if you need to be. If he says, no, I did not have the necessary consent, so you wasted your time, the maintenance court's time, the child's time, and lay a complaint at the Legal Practice Council. The old term was a law society. Do that, but go to the maintenance court and try to resolve this matter. And I think the law, yes. I'm just finding out where are the comments coming from, connecting it to the relevant client. Okay, I have a new comment over here. My son's father was ordered by court to pay maintenance arrears, which he only paid 3,000 rand, with 600 rand outstanding. Just after he got paid, he was dismissed from work due to drugs. He was told to come back when he is drug free. What will the court do? If somebody is unemployed and the person owes you money, arrear maintenance money, that arrear maintenance money stays, it remains. It doesn't go away. Obviously, I would advise you to go to the court and explain the situation to them. If the person has assets, those specific assets must be sold, but it seems to me that specific person does not have any of those specific assets. So the real amount remains. And if the person is not paying any maintenance, despite him being unemployed, and he never made an application to the maintenance court to have the maintenance order varied or set aside, the arrears are just escalating and climbing. There seems to be nothing much you can do at this present moment because he has been dismissed based upon drug use, and he can only come back to work once he is drug free, and that is most probably when he will start earning an income again. So where the father is concerned, it seems to me that's a bit of a waste of energy, but he may have parents who can afford to pay the maintenance on his behalf, and you may want to inquire into that as well. So my advice to you is go to the maintenance court, explain to them the situation. They might be able to assist you in obtaining that specific money. The employer might owe you money. There might be something which you can do with regard to the employer. There might be other assets applicable that you can attach and make use of. But I would say go to the maintenance court and they will be able to assist you and advise you better on the specific issue. Let me connect the commenters. Okay, we have another comment. Father has played his normal game. The father has played his normal game, has now become unemployed in order not to pay his maintenance. So now it is going back to court for review. He has sold all assets to avoid paying maintenance. Do I fight the grandparents now? If the father doesn't have any income and is unable to maintain the minor child, and those are legitimate reasons, then I would say go to the grandparents. That's the long and short of that. I cannot explain it any further because the child needs to eat and the father is not willing to do his part. The maintenance court obviously have to be reasonable. They'll have to determine, is it fair to go to the grandparents at that specific point? But however, if money cannot be taken from the father and the child needs to eat, the child needs clothing, obviously the maintenance court would be the proper forum to approach the grandparents on your behalf. Here we have another question. It goes as follows. Have been fighting my case for 2 years in the criminal court without a lawyer. The other party have a lawyer and abuse the system and delay. But now the NPA is on the case. If he is found guilty, what will the next step be if he doesn't accept the judgment? Can he appeal again and take it to the higher court? So let me explain quickly how does the maintenance criminal court work. There's no criminal maintenance court. It's not a normal criminal court. If somebody does not adhere to a maintenance order, he or she is committing a criminal offense, and a criminal complaint can be laid at court with the prosecutor. The prosecutor will look at it and he will decide to prosecute you for non-compliance with the maintenance order. You will not have a lawyer, of course not, because you will be a witness. He will have a lawyer to defend him. That's how it works. Same way, if you assault somebody at the criminal courts, the prosecutor will prosecute you, the accused person or the perpetrator. The person who is on the witness stand who has been assaulted, he or she will not have a lawyer. His or her lawyer basically will be the prosecutor, if for lack of a better way of stating it, because he will be the prosecutor's witness. Then they go on, but now the NPA is on the case. So it's possible to delay a criminal maintenance matter. Let's say you appear in court the first time, you say, I would like to get a lawyer on board. The lawyer is only available in a month's time. A month come later, you come to court, the lawyer says, hey, I require the following documentation. in order for me to know what's happening in this case. Gets postponed for another 2 months, and it can go on and on. Then the matter gets postponed for hearing, for trial. It gets postponed for maybe for plea and trial. On that specific date, the lawyer said, I'm not ready, something came about. So it can go on and on. However, at some point, the matter must proceed. The magistrate will get annoyed, exhausted, and at some point, he had to plea, and the matter must run. If the party is found guilty, as the questioner poses, and he does not accept the decision of the magistrate, he can appeal it, obviously, and is allowed to take it to the High Court. If you are unhappy with the decision of a magistrate's court, you have full right to appeal it. You must explain to the higher court, in this case the High Court, that the magistrate's court made an error. The evidence before it did not justify a decision of guilt on your part. So you're welcome to do that. The committee goes further, and I have an increased application in, but it cannot be heard until the criminal matter is finalized. And in the meantime, my expenses increases, but not the contribution from the other party. It's like there isn't much relief in the interim. The person goes further. Before I comment further, this is the last comment. We now go into trial on the 26th of March. I presume that's for the criminal case. The difficulty with maintenance matters and custody matters and any legal matter as such, if the other party does not want to come to the table, he or she can make life very difficult for you. The same way, if someone owes me money, I borrowed somebody 100 rand, and he does not want to pay it. He does not want to pay it. And I take him to court. He makes life very difficult in order for me to enforce my rights. The same applies for maintenance. If the specific person understands the system and understands that how can we deal with an application for an increase in maintenance if I'm already in arrears with my previous maintenance order because I now specifically stipulated that I cannot afford it, and that's my defense, that I could not have afforded it in the first place. How can there be a parallel hearing of the matter whereby the maintenance court will have to deal with the application for an increase, but at the same time there is an application pending in the criminal courts where the father says they cannot afford it? It makes us logical sense for the courts to deal with one matter at a time. Sometimes a party can take advantage of that. Sometimes the court will make a different decision. The court will say, the criminal matter can pend because we're dealing with an old issue, but now circumstances have changed. The father is now saying he can afford the maintenance, but now the issues concerning affordability based upon what the mother wants. But the criminal inquiry for non-compliance deal with something that happened a year ago. We did not pay for a few months, whatever the case may be. But my understanding is that the maintenance courts do not prosecute. Obviously, I'm speaking under correction here. Not all maintenance courts might follow this, but they do not prosecute you for non-compliance of maintenance if you pay the arrear maintenance immediately. So let's say somebody never paid for a year. They issue summons, you call to the maintenance court, you pay their arrears, they move on with their lives. So, in answering this questioner's question, and the trial being the 26th of March, see what happens in the criminal matter. A lot of information can come from the criminal inquiry because he will have to explain now all the circumstances. You will come on the witness stand, you will explain there was a maintenance order put in place. The maintenance order stipulated the following amounts would have to be paid. You would explain that he did not pay those specific amounts and so on, and he's in arrears for so much. He will come on the witness stand in his defense, and he will explain that he could not have afforded, whatever the case may be. Once that matter is finalized, the court might find him guilty, the court might find him innocent, but then the court can properly deal with the application for an increase. The best person to discuss this with would be with the court prosecutor, because they prosecute these type of matters, or the maintenance officer. Each court is different. Each criminal court has a different policy. It could be that a court might have an experience whereby if each time they prosecute these type of maintenance matters and the father starts paying the maintenance or the mother's pay the maintenance immediately after they've issued summons, it works. So that's a policy. So they do not proceed. Alternatively, they could have had a problem in the past where they run these type of matters parallel. It just causes much more problems and much more difficulty. Because now we are dealing with inquiry in a civil setting, in a maintenance court setting for an increase. But in the criminal court, evidence is being laid and laid out based upon the fact that the father could not have afforded in the first place. So we have this parallel situation which might not be in the best interest of justice. But also, finality of matters are very important. I would say the courts must be very fast and quick in dealing with these type of matters, and the sooner they can resolve it, the sooner the child's best interest can be upheld. Okay, I hope that answers that specific question. And the commenter made one final comment. She says as follows: affordability is not the defense, or rather, lack of funds is not the defense. Funds are plenty. Then it seems to me that he will be found guilty of that specific offense of non-compliance. And if they find him guilty because he could have afforded, then there's no reason why the application for an increase cannot be completed. And having said that, if affordability is not an issue and there is money available, then the maintenance court must start putting on the gloves and start fighting for you, and then they have to attach these specific funds or whatever money is, get a garnish order in place. The person said, thank you, you are welcome. If you have any other questions, and all the commenters that post comments early on, all 17 comments, you are welcome to pose additional questions and I'll try my best to answer it. If you are joining this video, please feel free to mention where you're from. We are from Cape Town. We have someone else, let me see now, from Somerset West. If you're anywhere out of Cape Town, somewhere north, Joburg, Eastern Cape, and so on, please feel free to leave a comment or say hi. I'll be keeping a close eye on the screen. Sometimes I have to first analyze the wording because people type from their phones, and I do not want to speak gibberish here. I don't blame you for typing from your phones. How else can you do it? And that's why sometimes I take a bit longer to read it out. And also I must strain my eyes to look into the screen. Oh, we have somebody from Roodepoort. Thank you. That's very nice to hear. It's nice to know where people are coming from. Thank you for that. Going back to today's topic and the theme of toughening up. Why do I say so? Why do I say so? Why do I say that you need to toughen up? And I'm not referring to you, please. I'm not referring to you. I'm trying to give a message out to people, and I cannot see it being a negative message. It can only help you in fighting for your rights and for that of your child. People are of the view, when I come with answers, when I come with suggestions, they always come with counter suggestions and counter answers that exhaust me a bit. They'll ask me the question, advocate, the father is not paying child maintenance, what can I do? I say the law expects you to approach a maintenance court. Advocate, if I go to the maintenance court, I know he says he can't afford it. There is it. He's not toughening up. Advocate, when I go to the maintenance court, I know the court will find in his favor because the father is charming. They're not working with you. You need to work with the lawyers. You need to work with the system. Advocate, when I tell them you need to approach a maintenance court, advocate, I do not have the time. Advocate, this is a lot of work for me to do. We will have time to complete all this income and expenditure. We will have the time to make photocopies. We will get the money to make the photocopies. Whereby clients obtain this very good advice on how to deal with the matter. So we're stuck there. I cannot deal with the issue concerning how the tactics I can advise her or him on how to win the maintenance court case. What ideas I have, what strategies I have. I cannot deal with that because I'm still dealing with this preliminary issue about going to the maintenance court, because every time I mention we're going to the maintenance court and fight the matter out there and battle it out for the client with putting on our boxing gloves and our brains and so on, I get an answer that is, becomes a bit challenging, a negative answer. We must have the time for this. I do not know how to use Excel. I do not know how to use a computer. I never went to university to learn how to use a computer. Oh, the maintenance court. I live in Cape Town, but the maintenance court that I must go to is like there. When will I have time? I must take time off work. And then the end of the day is, why did you come to my office? They came to my office for the sole reason thinking I can make one phone call and get the father to pay the child maintenance. You need to be smart. And many times the attitude Or maybe the theme which I have to apply to that specific scenario would be take ownership of your case. That's it, maybe. Okay, a lot of comments are coming in, and I do not want to lose any of them. We have now 26 comments that came in. Let's see what's happening here. Okay, Rudaput, welcome. The other commenter regarding the money being hidden away. I am in Somerset West. Awesome. What if the father is hiding his money in another account? The maintenance court, if you should do a bit of research, because we cannot look at every possible account, and that's a great possibility that he's doing that. It also might not be true. Maybe he's not also doing so. So you need to find specific links to assist you as to how you can potentially verify that he is hiding the money in a different account. And once you have identified that specific account, then you can approach the court for a subpoena to the bank to disclose that specific account. Okay. Or his family's account. So you need to identify that specific account. Once you know it is, you can take it further. I have another comment. It says, where is he hiding it? Transferred to his mother. I think that's an internal conversation, which is fine. You need to be your own investigator and help the court as much as possible. I agree with that comment over there. You need to take ownership of your case. Thank you for that. Thanks, will try my best. You are welcome, and do so. You know, magic only happens if you put the effort into it. Magic doesn't happen on its own. People learn to do wonderful things out there. Lose weight, surf, mountain climbing, abseiling, fly an aeroplane, because they make an effort. It's magic, but they made an effort. Same way with winning your child custody or child maintenance case. You put in the effort, you will win. The question here asks, can they summons her bank account? Yes, they can. You need to know what the bank account is and what the relevance of the matter is, and they can summons it. They can subpoena, put it that way, they can subpoena the bank for the bank statements. Another comment over here, you need to be on the court's case all the time. Yes, you need to hassle them. The more you hassle them, the more the time they get from you, of you, and they will try to expedite your specific case. Okay, comment yes. Thanks for the advice. You are welcome. We have another comment over here from someone else. Good day. Firstly, thank you for all your advice. You are welcome anytime. The short, my ex is taking me to court for the second time for a decrease, still outstanding from the first time. We're due for court on Monday. My question is, can I sue his parents as well? He does not have the respect for the system or the first. After the first time, he's still going on and doing his own thing. Yes, you can subpoena the parents. However, the court must first be, in my view, satisfied that there is no case against the father. If there is no case against the father, the children cost X amount of money, fine. But at the end of the day, the father and the mother together cannot come up with that specific money. Now we need to look at the higher tier, the grandparents. Then you can do so. My advice to you is speak to the maintenance court. Each court might have their own way of dealing with these type of matters on how to claim maintenance from grandparents. Do they do an inquiry the first time, or do they call the grandparents in all of a sudden? You need to determine from them how it works in your specific court, and once you know that, you're A4 away. But they'll be able to advise you on that. I hope that answers your specific question, and you're welcome to add additional comments. I have an additional comment. Going to the maintenance court, he made me become a dragon and a bulldog. Wonderful. Many people want to employ a dragon and a bulldog as a lawyer. If you can be your own one, obviously, with a lot of knowledge, I advise you to sharpen a sword. And how do you sharpen a sword? With a lot of knowledge. But you need to put a bit of energy also. So the sword can be super sharp. It won't melt through the meat or the whatever you're doing with a sword. Referring to cooking, you need to put a bit of muscle. So that's where the toughening up comes in. So know the law, that's the sharpness of the sword, but put a bit of energy in and toughen up a bit. The commenter earlier on says, thank you, you are welcome. Thank you for partaking in this webinar. And we got about 4 or 5 minutes left. I need to be offline by 11. Today is quite a busy one. We're having one again tomorrow morning. If you're watching this webinar, I'll be posting the time later today still, but tomorrow around this time I will be online again to answer whatever additional questions you may have. Someone is replying to a previous commenter, that's fine, I'll say what they're saying. The court investigator picked up my ex-secret bank account via his medical aid record. There's always ways and means. I agree with you 100%. You need to act like a investigator. You watch CSI, you watch all those cool movies. You know, there is a bit of logic behind that. Look through things. Use a highlighter. Highlighters are very good. So you highlight things, you know. Pencil marks. Later on, you might, oh, this specific name or this reference number came up before. Let me go back there, you know, and start working things out. Another comment. I have been in court for more than 2 years for arrears and current maintenance. A year ago, an agreement was made in the mediation in criminal court. Since then, no payment was made on the arrears, the current maintenance, or the current maintenance. That's a concern. I went back to court to let them know, and they will summons him back in March. What is expected at the hearing, seeing that I'm asked to be there? I would imagine it's a criminal matter that's being heard now, so they're subpoenaing him, and he needs to explain his specific circumstances. And if it's not the satisfactory circumstances, then of course they will maybe proceed with a criminal case again. So it seems to me the criminal matter was mediated and the charges were withdrawn and the parties came to an agreement. He did not comply with that agreement. The criminal matter will have to proceed again. That's my view. I hope that makes sense. But at the end of the day, after they've consulted with him, they will have to advise you and inform you of what has happened and also verify with you whether or not you are happy with that specific decision. The commenter says, thank you for your advice. You are welcome. Another comment, thank you for your continued guidance. We have Farida Williams, an attorney. You are welcome for that. And a final comment, and I'll cut it short here. Think I need to employ you to help me with going after the grandparents. I am happy to advise, and I'm certain you are competent enough, but when it comes to child maintenance, it's something very passionate. I'm very passionate about it because it deals with the food for the child, the clothing, and the amenities for the child's life. It's not like fighting for a client for other issues. Here we're dealing with money that must be paid, and I'm very angry if a parent does not pay an adequate amount. If the adequate amount which you can afford is 50 Rand per month, then that's free because you worked hard and you pay the 50 Rand, and that's fine. But if somebody does not want to pay child maintenance, that is very disappointing. Please, if you're watching this video, please share this video. Other people might find it very useful. We're online for 34 minutes now, and we had 36 comments. Thank you very much for that. I have another webinar now at 11 o'clock. I hope you enjoyed this video. I'll see you tomorrow online again. Please type out your questions before the time so you can just copy and paste it and put it on the screen. Have a lovely day, and I'll see you tomorrow online. Thank you for all your participation.